Jurisdiction of civil courts. The fundamental principle of English law that wherever there is a right, there is a remedy, ubi jus, abi remedium, has been adopted by the Indian legal system also. In fact, the right and remedy are but the two sides of the same coin, and they cannot be separated from each other. Accordingly, a litigant having a grievance of a civil nature has the right to institute a civil suit in a competent civil court unless its cognizance is specifically barred. Either expressly or impliedly, by any statute. A suit for its maintainability requires no authority of law. It is enough that no statute bars it. Specific positive provision is not required, only a negative provision. If it is not there, then you have a right. Jurisdiction meaning. The term jurisdiction has not been defined in the code. The word jurisdiction is derived from Latin juris and dido, which means I speak by the law. Stated simply, jurisdiction means power or authority of a court of law to hear and determine a cause or a matter. It is the power to entertain, deal with, and decide a suit, an action, petition, or other proceeding. In other words, by jurisdiction is meant the authority which a court has to decide matters that are litigated before it, or to take cognizance of matters presented in a formal way for its decision. Thus, jurisdiction of a court means the extent of authority of a court to administer justice prescribed with reference to the subject matter, pecuniary value, and local limits. Three things: subject matter, pecuniary value, and local limits. In the official trustee versus Sachidananda Nath, after referring to various decisions, Supreme Court observed, from the above discussion, it is clear that before a court can be held to have jurisdiction to decide a particular matter, it must not only have jurisdiction to try the suit brought, but must also have the authority to pass the orders sought for. It is not sufficient that it has some jurisdiction in relation to try the suit brought, but must also have the authority to pass the orders sought for. Subject matter of the suit. Its jurisdiction must include the power to hear and decide the question at issue, the authority to hear and decide particular controversy that has arisen between the parties. Jurisdiction of civil courts. Jurisdiction and consent. It is well settled that consent cannot confer nor take away any jurisdiction of a court. In the leading case, A.R. Antule versus B.S. R.S. Naik, Mukherjee judge, as it then was, stated that this court, by its directions, could not confer jurisdiction on the High Court of Bombay to try any case for which it did not possess. It was further stated that the power to create or enlarge jurisdiction is legislative in character, so also the power to confer a right of appeal or to take away a right of appeal. Parliament alone can do it by law, and no court, whether superior or inferior or both combined, can enlarge the jurisdiction of a court or divest a person of his right of revision and appeal. If the court has no inherent jurisdiction, neither acquiescence nor waiver nor estoppel can create it. A defect of jurisdiction goes to the root of the matter and strikes at the authority of a court to pass a decree. Such a basic and fundamental defect cannot be cured by consent of parties, and the judgment or order passed by a court, however precisely certain and technically correct, is null and void, and the validity thereof can be challenged at any stage. A decree passed without jurisdiction is non-est, does not exist, and its validity can be set up whenever it is sought to be enforced as a foundation for a right, even at the stage of execution for its decision. The limits of this authority are imposed by status or charter or commission under which the court is constituted, and may be extended or restricted by similar means. If no restriction or limitation is imposed, the jurisdiction is said to be unlimited. A limitation may be either as to the kind or nature of action, or the matter of which a particular court has cognizance, or as to the area over which the jurisdiction extends, or it may partake of both these characteristics, or in a collateral proceedings. In short, a decree passed by a court without jurisdiction is quorum non juris. In the case of Kiran Singh versus Chaman Paswan, the Supreme Court observed, it is a fundamental principle well established that a decree passed by a court without jurisdiction is a nullity, and that its invalidity could be set up whenever and wherever it is sought to be enforced or relied upon, even at the stage of execution or even in collateral proceedings. A defect of jurisdiction strikes at the very authority of the court to pass any decree, and such a defect cannot be cured even by consent of the parties. Conversely, where a court has jurisdiction to decide a dispute, the same cannot be taken away or ousted by consent of the parties. An agreement to oust absolutely the jurisdiction of the court would be unlawful and void, being against public policy. Ex dolo malo, non oritur actio. But if two or more courts have jurisdiction to try the suit, it is open to the parties to select a particular forum, that is called forum shopping, and exclude the other forums, and therefore the parties may agree among themselves that the suit should be brought in one of those courts and not in the other, since there is no inherent lack of jurisdiction in the court. Such an agreement would be legal, valid, and enforceable. Lack of jurisdiction and irregular exercise of jurisdiction. There is always a distinction between want of jurisdiction and irregular exercise of it. If once it is held that a court has the jurisdiction to entertain and decide a matter, the correctness of the decision given cannot be said to be without jurisdiction, inasmuch as the power to decide necessarily carries with it the power to decide wrongly as well as rightly. Jurisdiction of civil courts. In other words, a court has jurisdiction to decide wrong as well as right. If it decides wrong, the wronged party can only take the course prescribed by law for setting matters right. And if that course is not taken, the decision, however wrong, cannot be disturbed. In other words, if there is inherent lack of jurisdiction, the decree passed by a civil court is a nullity, and that nullity can be set up in any collateral proceedings. However, if a court has jurisdiction and it is irregularly exercised, the defect does not go to the root of the matter, and the error, if any, in exercising jurisdiction can be remedied in appeal or revision. And when there is no such remedy is not availed of, the decision becomes final and it cannot be disturbed. In Ittavira Mathai versus Varke, it was contended that the decree passed by the court was a nullity since the suit was time barred. Negating that contention, the Supreme Court observed, if a suit was barred by time and yet the court decreed it, the court would be committing an illegality, and therefore the aggrieved party would be entitled to have the decree set aside by preferring an appeal against it. But it is well settled that a court having jurisdiction over the subject matter of the suit and over parties thereto, though bound to decide the right, may decide wrong also, and that even though it is decided wrong, it would not be doing something which it has no jurisdiction to do. If the party aggrieved does not take appropriate steps to have that error corrected, the erroneous decree will hold good and will not be open to challenge on the basis of a nullity. The difficult question, however, is what is the distinction between the absence of jurisdiction and erroneous or irregular exercise thereof. Ibrahim Abu Bakr versus Custodian General of Vacui Property. Where a quasi-judicial authority has jurisdiction to decide a matter, it does not lose its jurisdiction by coming in to a wrong conclusion, whether it is wrong in law or in fact. After the landmark decision in Anismenic versus Foreign Compensation Commission, the legal position is considerably changed. It virtually assimilated the distinction between lack of jurisdiction and erroneous exercise thereof. As observed in M.L. Sethi versus R.P. Kapoor, the difference between jurisdictional error and error of law within jurisdiction has been reduced almost to a vanishing point. The following observation pithily puts the legal position thus. After anismenic, every error of law is a jurisdictional error. The distinction between jurisdictional and non-jurisdictional error is ultimately based upon a foundation of sand. Quicksand. Much of the superstructure has already crumbled. What remains is quite likely to fall away, as the courts rightly insist that all administrative actions should simply be lawful, whether or not jurisdictionally lawful. Basis to determine jurisdiction. It is well settled that for deciding the jurisdiction of a civil court, the amendments made in the plain term material. To put it differently, the jurisdiction of a court should normally be decided on the basis of a case put forward by the plaintiff in his plaint and not by the defendant in his written statement. Thus, in Abdullah bin Ali versus Galappa, the plaintiff filed a suit in the civil court for declaration of title and for possession and mesne profits, treating the defendants as trespassers. The defendant contended that the civil court had no jurisdiction since he was a tenant. Negativing the contention of the defendants, Supreme Court observed there is no denying the fact that the allegations made in plaint decide the forum. The jurisdiction does not depend upon defense taken by the defendants in the written statement. On a reading of the plaint as a whole, it is evident that the plaintiff appellants had filed the suit, giving rise to the present appeal, treating the defendants as trespassers as they denied the title of the plaintiff appellants. Now, a suit against the trespasser would lie only in a civil court and not in a revenue court. We are therefore of the considered opinion that on the allegations made in the plaint, the suit was cognizable by a civil court. The plaintiff, however, cannot be drafting his plaint, cleverly circumventing the provision of law in order to invent jurisdiction in a civil court, which it does not possess. It is also well settled that in deciding the question of jurisdiction, what is important is the substance of the matter and not the form. Thus, in Bank of Baroda versus Modi Bhai, the plaintiff bank lent a certain amount to the defendant in the usual course of its commercial business. By way of collateral security, however, it obtained a hypothecation bond and a deed of mortgage from the defendant under the Tenancy Act, conferring exclusive jurisdiction on the revenue court. When the suit was filed in the civil court for recovery of amount, it was contended by the defendant that the civil court had no jurisdiction to try the suit. Negativing the contention, the Supreme Court observed that the business of the bank was to lend money. If only by way of collateral security the bank obtains a hypothecation bond or a deed of mortgage, the provisions of the Tenancy Act cannot be attracted. Primarily and basically, the suit filed by the bank was for the recovery of the amount due to it by the defendant on the basis of the promissory note executed by the defendant. The main relief sought by the bank was that the suit should be decreed for repayment of amount. The civil court had therefore jurisdiction to entertain the suit filed by the bank. On the question of jurisdiction, one must always have regard to the substance of the matter and not to the form of the suit. Again, when a court of limited jurisdiction, that is rent controller, has jurisdiction to decide only a particular dispute, fixation of a standard rent, it has jurisdiction to consider the collateral issue, title of the landlord to the property, only prima facie, and the jurisdiction of a civil court to decide such issue finally is not taken away by the rent controller. It is submitted that the following observations of the full bench of Allahabad High Court in Ananti versus Chanu and approved by the Supreme Court lays down the correct law on the point. The plaintiff chooses his forum and files his suit. If he establishes the correctness of his facts, he will get his relief from the forum chosen. If he frames his suit in a manner not warranted by the facts and goes for his relief to a court which cannot grant him relief on true facts, he will have his suit dismissed, and then there will be no question of returning the plaint for presentation to the proper court, for the plaint, as framed, would not justify the other kind of court to grant him the relief. If it is found on a trial on the merits, as far as this issue of jurisdiction goes, that the facts alleged by the plaintiff are not true, and the facts alleged by the defendants are true, and that the case is not cognizable by the court, then there will be two kinds of orders to be passed. If the jurisdiction is only one related to territorial limits or pecuniary limits, the plaint will be ordered to be returned for presentation to the proper court. If, on the other hand, it is found that having regard to the nature of the suit, it is not cognizable by the class of court to which the court belongs, the plaintiff's suit will have to be dismissed in its entirety. Jurisdictional fact. The jurisdiction of a court, tribunal, or authority may depend upon fulfillment of certain conditions or upon existence of a particular fact. This is called jurisdictional fact. The existence of such a preliminary or a collateral fact is a sine qua non or a condition precedent to the assumption of jurisdiction by the authority. If it exists, the authority has jurisdiction and it can act. If it does not exist, there is no jurisdiction and the authority cannot act. If the authority wrongly assumes the existence of such a fact, a writ of certiorari can be issued. Decision as to jurisdiction. Whether a court has jurisdiction or not has to be decided with reference to the initial assumption of jurisdiction by that court. The question depends not on the truth or falsehood of the facts into which it has to inquire, or upon the correctness of the findings on these facts, but upon their nature, and it is determinable at the commencement, not at the conclusion of inquiry. Whenever the jurisdiction of a court is challenged, that court has inherent jurisdiction to decide the said question. Every court or tribunal is not only entitled but bound to determine whether the matter in which it is asked to exercise its jurisdiction comes within its jurisdiction or not. Similarly, where a tribunal derives its jurisdiction from the statute and creates it and imposes condition under which it can function, it goes without saying that before the tribunal assumes jurisdiction in a matter, it must be satisfied that those conditions in fact exist. Such facts are known as preliminary or jurisdictional facts. Courts and tribunals. A civil court has inherent power to decide the question whether it has jurisdiction to entertain, deal with, and decide the matter which has come before it. The jurisdiction of a tribunal or any other authority stands on a different footing, where Parliament has invested such tribunal with power to decide and determine finally the preliminary facts on which its jurisdiction depends. It can decide such facts, and finding recorded by the tribunal cannot be challenged by a certiorari writ. But where a statute creating or establishing a tribunal does not confer that power on a tribunal, an inferior tribunal cannot, on a wrong decision on preliminary or a collateral fact, assume and confer on itself jurisdiction which it does not possess. Such an order can be challenged by certiorari writ. Jurisdiction of foreign courts. Kinds of jurisdiction. Jurisdiction of a court may be classified under the following categories: civil and criminal jurisdiction. Civil jurisdiction is that which concerns and deals with disputes of a civil nature. Criminal jurisdiction, on the other hand, relates to crimes and punishes offenders. Second, territorial or local jurisdiction. Every court has its own local or territorial limits beyond which it cannot exercise its jurisdiction. These limits are fixed by the government. The district judge has to exercise jurisdiction within his district and not outside of it. The High Court has jurisdiction over territory of a state within which it has to situate and not beyond it. Again, a court has no jurisdiction to try a suit for movable property situate beyond its local limits. Pecuniary jurisdiction. The court provides that a court will have jurisdiction only over those suits, the amount or value of the subject matter of which it does not exceed the pecuniary limits of jurisdiction. Some courts have unlimited pecuniary jurisdiction. Example, high courts and district courts have no pecuniary limitation, but there are other courts having jurisdiction to try suits up to a particular amount. Thus, the Presidency Small Causes Court cannot entertain a suit in which the amount claimed is more than 1,000 rupees. Now it has gone up to 2,000 or 3,000 rupees. The jurisdiction as to the subject matter. Different courts have empowered to decide different types of suits. Certain courts are precluded from entertaining certain suits. Thus, the Presidency Small Causes Court has no jurisdiction to try suits for specific performance of a contract, partition of immovable property, foreclosure of redemption of a mortgage, etc. Similarly, in respect of testamentary matters, divorce cases, probate proceedings, insolvency proceedings, etc., only district judge or a civil judge, senior division, has jurisdiction, original and appellate jurisdiction. Original jurisdiction is the jurisdiction inherent in or conferred upon a court at the first instance. In the exercise of this jurisdiction, a court of first instance decides suits, petitions, or applications. Appellate jurisdiction is the power or authority conferred upon a superior court to hear, rehear, by way of appeal, revision, etc., of causes which have been tried and decided by courts of original jurisdiction. Municipal courts, court of civil judges, small causes courts are having original jurisdiction only, while district courts, high courts have original as well as appellate jurisdiction. Exclusive and concurrent jurisdiction. Exclusive jurisdiction is that which confers the sole power on one court or a tribunal to try, deal with and decide a case. No other court or authority can render a judgment, give a decision in the case or a class of cases. Concurrent and coordinate jurisdiction is the jurisdiction which may be exercised by different courts or authorities between the same parties at the same time and over the same subject matter, and therefore is open to a litigant to invoke jurisdiction of any such court or authority. General and special jurisdiction. General jurisdiction extends to all cases comprised within a class or classes of causes. Special or limited jurisdiction, on the other hand, is the jurisdiction which is confined to a special or a particular or limited causes. Legal and equitable jurisdiction. Legal jurisdiction is a jurisdiction exercised by common law courts in England, while equitable jurisdiction is a jurisdiction exercised by equity courts. Courts in India are courts of both law as well as equity. Municipal and foreign jurisdiction. Municipal or domestic jurisdiction is a jurisdiction exercised by municipal courts, that is, courts in a country. Foreign jurisdiction means jurisdiction exercised by a court in a foreign country. A judgment rendered or decision given by a foreign court is a foreign judgment. Expounding or expanding jurisdiction. Expounding jurisdiction means to define, clarify, and explain, that is, expound the jurisdiction. Expanding jurisdiction means to expand, enlarge, or extend. It is the duty of the court to expound its jurisdiction. It is, however, not proper for the court to expand its jurisdiction. Jurisdiction of civil courts, section 9. Under the Code of Civil Procedure, the civil court has jurisdiction to try all suits of a civil nature unless they are barred expressly or by implication. Section 9 of the Code reads as follows: The court shall, subject to provisions herein contained, have jurisdiction to try all suits of civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. Explanation 1a. Suit in which the right to property or to an office is contested is a suit of civil nature, notwithstanding that such a right may depend entirely on the decision of questions as to religious rites or ceremonies. Explanation 2. For the purpose of this section, it is immaterial whether or not any fees are attached to the office referred to in Explanation 1 or whether or not such office is attached to a particular place. Conditions. A civil court has jurisdiction to try a suit if two conditions are fulfilled. 1. The suit may be a civil nature and the cognizance of such a suit should not be expressly or impliedly barred. Now, suit of a civil nature. The meaning: in order that a civil court may have jurisdiction to try a suit, the first condition which must be satisfied is that the suit must be of a civil nature. By what is a suit a civil nature? The word civil has not been defined in the code, but according to the dictionary meaning, it pertains to private rights and remedies of a citizen as distinguished from criminal, political, or public rights. The word nature has been defined in the fundamental qualities of a person or a thing, identity or essential character, sort, kind, character. It is thus wider in content. The expression civil nature is wider than the expression civil proceeding. Thus, a suit is of a civil nature if the principal question therein relates to the determination of a civil right and enforcement thereof. It is not the status of the parties to the suit, but the subject matter of it, which determines whether or not the suit is of a civil nature. Nature and scope. The expression suit of a civil nature will cover private rights and obligations of a citizen. Political and religious questions are not covered by that expression. A suit in which the principal question relates to caste or religion is not a suit of civil nature, But if the principal question in a suit is of a civil nature, the right to property or to an office, and the adjudication incidentally involves the determination relating to a quaest question or to religious rites or ceremonies, it does not cease to be a suit of civil nature. And the jurisdiction of a civil court is not barred. The court has jurisdiction to adjudicate upon questions also in order to decide the principal question, which is of civil nature. Explanation 2 has been added by the Amendment 1976. Before this explanation, there was a divergence of judicial opinion as to whether a suit relating to a religious office to which no fees or emoluments were attached can be said to be a suit of civil nature. But the legal position has now been clarified by Explanation 2, which specifically provides that the suit relating to a religious office is maintainable whether or not it carries any fees or whether or not it is attached to a particular place. The doctrine explained. Explaining the concept of jurisdiction of civil courts under Section 9, PMA Metropolitan versus More Mar Marthoma. The Supreme Court stated the expansive nature of the section is demonstrated by use of phraseology both positive and negative. The earlier part opens the door widely and the latter part debars the entry to only those which are expressly or impliedly barred. The two explanations, one existing free from inception and the latter added in 1976, bring out clearly the legislative intention of the extending operations of the section to such religious matters where the right to property or office is involved irrespective of whether any fees is attached to the office or not. The language used is simple but explicit and clear. It is structured on the basic principle of a civilized jurisprudence that absence of machinery for enforcement of right renders it nugatory. The heading, which is normally key to the section, brings out unequivocally that all civil suits are cognizable unless barred. What is meant by it is explained further by widening the ambit of the section by use of the word shall and the expression all suits of a civil nature, unless expressly or impliedly barred. Each word and expression casts an obligation on the court to exercise jurisdiction for enforcement of right. The word shall makes it mandatory. No court can refuse to entertain a suit if it is of the description mentioned in the section. That it is amplified by the use of expression all suits of a civil nature. The word civil, according to dictionary, means relating to the citizen as an individual civil rights. In Black's Law Dictionary, it is defined as relating to provide rights and remedies sought by civil actions as contrasted with criminal proceedings. In law, it is understood as any antonym of criminal. Historically, the two broad classifications are civil and criminal. Revenue, tax and company were added later on. But they too pertain to the large family of civil nature. There is thus no doubt that the width of the word civil, its width has been stretched further by use of the word nature along with it. That is, even those suits are cognizable which are not only civil but are even of civil nature. The word nature has been defined as the fundamental qualities of a person or a thing, identity or essential character, sort or character. It is thus wider in content. The word civil nature is wider than the word civil proceeding. The section would therefore be available in every case where the dispute was of a characteristic of one's affecting one's rights, which are not only civil but of civil nature. Test. A suit in which a right to property or to an office is contested is a suit of civil nature, notwithstanding that such right may depend entirely on the decision of a question as to religious rites or ceremonies. Suits of civil nature illustrations. The following are suits of civil nature. There are examples. Suits relating to right to property, suits relating to right to worship, suits relating to taking out religious procession, suit relating to right to share in offerings, suits for damages for civil wrongs, suits for specific performance of contracts or for damages or for breach of contracts, suit for specific reliefs, suit for restitution of conjugal rights, suits for dissolution of marriages, suit for rents, suit for or on accounts, suit for rights of franchise, suits for rights to hereditary office, suits for right to Yajamana Vritti, suits against wrongful dismissals from service and for salaries, suits not of civil nature. Illustrations. The following are not suits of civil nature. 1. Suits involving principally caste question, suits involving purely religious rites or ceremonies, suits for upholding mere dignity or honor, suit for recovery of voluntary payments or offerings, suit against expulsion from caste, etc. Next, cognizance, not barred. As stated above, a litigant having a grievance of a civil nature has a right to institute a civil suit unless its cognizance is barred, either expressly or impliedly. Suits expressly barred. A suit is said to be expressly barred when it is barred by an enactment for the time being in force. It is open to a competent legislature to bar jurisdiction of civil courts with respect to a particular class of suits or of civil nature, provided that in doing so it keeps itself within the field of legislation conferred on it and does not contravene any provisions of the Constitution. But every presumption should be made in favor of the jurisdiction of civil court, and the provision of exclusion of jurisdiction of a court must be strictly construed. If there is any doubt about ousting of jurisdiction of a civil court, a court will lean to an interpretation which would maintain the jurisdiction, not remove it. Thus, matters falling within the exclusive jurisdiction of revenue courts under the Code of Criminal Procedure, matters dealt with by special tribunals under relevant statutes like Industrial Tribunal, Election Tribunal, Revenue Tribunal, Rent Tribunal, Cooperative Tribunal, Income Tax Tribunal, Motor Accident Claim Tribunal, etc., or by domestic tribunals like Bar Council, Medical Council, University, Club, are expressly barred from cognizance of a civil court. But if the remedy provided by a statute is not adequate and all questions cannot be decided by a special tribunal, the jurisdiction of a civil court cannot be barred. Similarly, when a court of limited jurisdiction prima facie and incidentally states something, the jurisdiction of a civil court to finally decide the time is not ousted. Next, suits impliedly barred. A suit is said to be impliedly barred when it is barred by general principles of law. Where a specific remedy is given by a statute, it is thereby deprives the person who insists upon a remedy of any other form other than that given by the statute. Where an act creates an obligation and enforces its performance in a specified manner, that performance cannot be enforced in any other manner. Similarly, certain suits, though of civil nature, are barred from cognizance of a civil court on the ground of public policy. The principle underlying is that a court ought not to countenance matters which are injurious to and against the public weal. Thus, no suit shall lie for recovery of costs incurred in a criminal prosecution or for enforcement of a right upon a contract hid by Section 23 of the Indian Contract Act, or against any judge for acts done in course of his duties. Likewise, the political questions belong to the domain of public administration law and are outside the jurisdiction of civil courts. A civil court has no jurisdiction to adjudicate upon disputes of a political nature. Who may decide? It is well settled law that the civil court has inherent power to decide on its own jurisdiction. Presumption as to jurisdiction. In dealing with the question whether a civil court jurisdiction to entertain a suit is barred or not, it is necessary to bear in mind that every presumption should be made in favor of the jurisdiction of a civil court. The exclusion of jurisdiction of a civil court to entertain civil causes should not be readily inferred unless the relevant statute contains an express provision to that effect and leads to a necessary and inevitable implication of that nature. Next, burden of proof. It is well settled that it is for the party who seeks to oust the jurisdiction of a civil court to establish it. It is equally well settled that a statute ousting the jurisdiction of a civil court must be strictly construed. Where such a contention is raised, it has to be determined in the light of the words used in the statute, the scheme of the relevant provisions, and the object and purpose of the enactment. In a case of doubt as to the jurisdiction, the court should lean towards assumption of jurisdiction. A civil court has inherent power to decide the question of its own jurisdiction, although as a result of such inquiry, it may turn out that it has no jurisdiction to entertain the suit. That means it finally decides and comes to a conclusion that it has no power to decide. 6. Objection as to jurisdiction. 7. Exclusion of jurisdiction limitations. A litigant having a grievance of a civil nature has, independent of any statute, a right to institute a suit in a civil court unless its cognizance is either expressly or impliedly barred. The exclusion of the jurisdiction of a civil court is not to be readily inferred, and such exclusion must be clear in the statute. Again, when jurisdiction of a civil court is barred, either expressly or by necessary implication, it cannot be said that the jurisdiction is altogether excluded. A court has jurisdiction to examine whether the provisions of the Act and the rules made thereunder have or have not been complied with, or the order is contrary to law, mala fide, ultra-vires, perverse, arbitrary, purported, violative of principles of natural justice, or is based on no evidence, and so on. In all these cases, the order cannot be said to be under the Act but is dehors the Act, and the jurisdiction of a civil court is not ousted to decide these particular things before the subject matter. In a leading decision, Secretary of State versus Mask and Company, the Privy Council rightly observed, it is a settled law that the exclusion of jurisdiction of a civil court is not to be readily inferred, but that such exclusion must either be explicitly expressed or clearly implied. It is also well established that even if the jurisdiction is so excluded, the civil courts have jurisdiction to examine into cases where the provisions of the Act have not been complied with, or the statutory tribunal has not acted in conformity with the fundamental principles of judicial procedure. It is respectfully submitted that the following observations of Subbarao J. Then was in the leading case of firm Seth Radha Kishan versus Administration Municipal Committee in Ludhiana laid down the correct legal position regarding jurisdiction of civil courts and requires to be reproduced. Under Section 9 of the Act CPC, the court shall have jurisdiction to try all suits of civil nature, excepting suits of which cognizance is either expressly or impliedly barred. A statute, therefore, expressly or by necessary implication, can bar the jurisdiction of civil courts in respect of a particular matter. The mere conferment of special jurisdiction on a tribunal in respect of the said matter does not in itself exclude the jurisdiction of civil courts. The statute may specifically provide for ousting the jurisdiction of civil courts, even if there was no such specific exclusion. If it creates a liability not existing before and gives a special and particular remedy for its aggrieved party, the remedy provided by it must be followed. The same principle would apply if the statute had provided for the particular forum in which the remedy can be had. Even in such cases, the civil court's jurisdiction is not completely ousted. A suit in a civil court will always be to question the order of a tribunal created by statute, even if its order is expressly or by necessary implication made final. If the said tribunal abuses its power or does not act under the Act but in violation of the provisions. Exclusion of jurisdiction of a civil court principles. From the above discussion, it is clear that the jurisdiction of civil courts is all-embracing except to the extent it is excluded by law or by clear intendment arising from such law. It is a classic decision of Dulabai versus State of MP. After considering a number of cases, Hidayatullah, Chief Justice, summarized the following principles relating to the exclusion of jurisdiction of civil courts. A. Where a statute gives finality to orders of a special tribunals, the civil court's jurisdiction must be held to be excluded if there is adequate remedy to do what the civil courts would normally do in a suit. Such a provision, however, does not exclude those cases where the provisions of a particular act have not been complied with or the statutory tribunal has not acted in conformity with the fundamental principles of judicial procedure. Where there is an express bar of jurisdiction of a court, an examination of a scheme of a particular act to find the adequacy or sufficiency of the remedies provided by the relevant, but that is not decisive for sustaining the jurisdiction of a civil court. Where there is no express exclusion, the examination of the remedies and the scheme of a particular act to find out the intendment becomes necessary, and the result of the inquiry may be decisive. In the latter case, it is necessary to see if the statute creates a specific right or a liability, and provides for a determination of a right or liability, and further lays down that all questions about the said right or liability shall be intertwined and shall be determined. By the tribunals as so constituted, and whether remedies normally associated with actions in civil courts are prescribed by the said statute or not. Challenge to the provisions of a particular act as ultra-vires cannot be brought before tribunals constituted under that act. Even the High Court cannot go into the question on a revision or a reference for a decision of tribunals. When a provision is already declared unconstitutional or the constitutionality of any provision is to be challenged, a suit is open. A writ of certiorari may include a direction to refund if the claim is clearly within the item prescribed by the Limitation Act, but it is not a compulsory remedy to replace a suit. Where the particular act contains no machinery for refund of tax collected in excess of constitutional limits or is illegally collected, a suit lies. A question of correctness of an assessment apart from its constitutionality or from the decision of authorities and a civil suit does not lie itself if the orders of the authorities are declared to be final and there is an express prohibition in a particular act. In either case, the scheme of a particular act must be examined because it is relevant inquiry. An exclusion of jurisdiction of a civil court is not readily to be inferred unless the conditions above set down apply. The above principles enunciated are relevant in deciding the correctness or otherwise of assessment orders made under taxing statutes. In Premier Automobiles versus Kamlekar Shantaram, the Supreme Court laid down the following principles. As applicable to jurisdiction of a civil court, in relation to industrial disputes. If a dispute is not an industrial dispute, nor does it relate to enforcement of any other right under the Act, the remedy lies only in a civil court. If a dispute is an industrial dispute arising out of a right or a liability under general or common law and not under the Act, the jurisdiction of a civil court is alternative, leaving it to the election of a suitor or a person concerned to choose his remedy for the relief which is competent to be granted to a particular remedy. If an industrial dispute relates to the enforcement of a right or an obligation created under the Act, then only remedy available to a suitor is to get an adjudication under the Act. If the right which is sought to be enforced is the right created under the Act, such as Chapter 5A, then the remedy for its enforcement is either Section 33C or raising of an industrial dispute, as the case may be. Again, in Rajasthan SRTC versus Krishnakant, after considering all the decisions in the point, the Supreme Court summarized the principles applicable to the industrial disputes thus: where a dispute arises from a general law of contract, that is, where reliefs are claimed on the basis of a general law of contract, a suit filed in a civil court cannot be said to be not maintainable, even though such a dispute may also constitute an industrial dispute within the meaning of Section 2K or Section 2A of Industrial Dispute Act. Where, however, a dispute involves recognition, observance, or enforcement of any rights or obligations created by the Industrial Dispute Act, the only remedy is to approach the forums created by the said Act. Similarly, where a dispute involves recognition, observance, or enforcement of rights and obligations created by enactments like the Industrial Employment Standing Order Act 1946, which can be called sister enactments of the Industrial Dispute Act and which do not provide a forum for resolution of such disputes, the only remedy shall be to approach the forums created by Industrial Dispute Act provided they constitute industrial disputes within the meaning of Section 2K and Section 2A of the Industrial Dispute Act, and where such enactment says that such dispute shall be either treated as an industrial dispute or says that it shall be adjudicated by any of the forums created by Industrial Dispute Act, otherwise the recourse to a civil court is open. It is not correct to say that remedies provided by the Industrial Dispute Act are not equally effective for the reason that access to a forum depends upon a reference being made by the appropriate government. The power to make a reference conferred upon the government is to be exercised to effectuate the object of the enactment, hence it is not unguided. The rule is to make a reference unless, of course, the dispute raised is a totally frivolous one ex facie. The power conferred is the power to refer and not the power to decide, though it may be that the government is entitled to examine whether the dispute is ex facie frivolous, not meriting adjudication. Next, consistent with the policy of a law aforesaid, we commend to Parliament and state legislatures to make a provision enabling a workman to approach the Labour Court or Industrial Tribunal directly, that is, without the requirement of a reference by the government in case of industrial disputes covered by Section 2A of Industrial Dispute Act. This would go a long way in removing the misgivings with respect to effectiveness of the remedies provided by the Industrial Dispute Act. The certified standing orders framed in accordance with the Industrial Employment Standing Order Act 1946 are statutorily imposed conditions of service and are binding upon both employers and employees, though they do not amount to statutory provisions. Any violation of these standing orders entitles an employee to appropriate relief either before a forum created by Industrial Dispute Act or in a civil court, which recourse to a civil court is open according to principles indicated therein. The policy of law emerging from the Industrial Dispute Act and its sister enactments is to provide an alternative dispute resolution. Mechanism to workmen, a mechanism which is speedy, inexpensive, informal, unencumbered by the plethora of procedural laws, and appeals upon appeals and revision applicable to civil courts. Indeed, the power of courts and tribunals under the Industrial Dispute Act are far more extensive in a sense that they can grant such relief as they think appropriate in the circumstances for putting an end to the industrial dispute. In Chandrakant versus Municipal Corporation, Ahmedabad, Supreme Court reiterated the principles laid down in earlier decisions and stated, it cannot be disputed that the procedure followed by civil courts are too lengthy and consequently are not as efficacious a forum for resolving the industrial disputes speedily. The power of industrial courts also is wide, and such forums are empowered to grant adequate relief as they think just and appropriate. It is in the interest of the workmen that their disputes, including the dispute of illegal termination, are adjudicated upon by industrial forums only. Next, general principles. From various decisions of Supreme Court, the following general principles relating to jurisdiction of a civil court emerge. 1. A civil court has jurisdiction to try all suits of civil nature unless their cognizance is barred either expressly or impliedly. 2. Consent can neither confer nor take away jurisdiction of a court. 3. A decree passed by a court without jurisdiction is a nullity, and the validity thereof can be challenged at any stage of the proceedings, in execution proceedings or even in collateral proceedings. 4. There is a distinction between want of jurisdiction and irregular exercise thereof. 5. Every court has inherent power to decide the question of its own jurisdiction. 6. Jurisdiction of a court depends upon the averments made in the plaint and not upon the defense in a written statement. 7. For deciding jurisdiction of a court, the substance of a matter and not its form is important. 8. Every presumption should be made in favor of jurisdiction of a civil court. 9. A statute ousting jurisdiction of a court must be strictly construed. 10. Burden of proof of exclusion of jurisdiction of a court is on the party who asserts it. 11. Even where jurisdiction of a civil court is barred, it can still decide whether the provisions of an act have been complied with or whether an order was passed, dehors the provisions of law. This is jurisdiction complete.